Next matter to come before the court this morning is the State of Ohio versus Nicole, Villegas.
Yes, Your Honor.
Each party will have 15 minutes for which to present the case. If you're the appellant, wish to retain some of that time for rebuttal, let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded and posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
May it please the court. My name is Attorney Denise Wilms, and I represent the appellant in this case, Nicole Villegas. We're here because Ms. Villegas was found guilty of reckless homicide, a felony 3, which was a lesser-included offense of murder, a felony 2, and 2 counts of felonious assault. Your Honors, here we're arguing that there was juror bias in this case. There were several jurors that had expressed a credibility issue with law enforcement officer witnesses. The state of Ohio in this trial presented only law enforcement witnesses, and there were 8 different jurors that said that they could not, or that they would put an officer credibility or an officer's testimony higher than that of a regular lay witness or anyone else. So, for instance, juror number 2, I totally respect police officers, and if they're on the stand, I'm going to believe them because that's their job. Juror number 5, I lean toward the police officer's testimony first as being credible, honest, and straightforward, having no bias and no prejudice. That's what happened. They were there. They saw it. He then later said, I'm still going to put more weight on the police officer testimony. Juror number 8, when it comes to a police officer's word against someone else's, I would have to see some reason that the police officer would be deceptive, that he wouldn't tell the truth. I didn't see any motivation behind sometimes law enforcement's not telling the truth. It's their job, they take an oath. So this goes on and on. Juror number 9, juror number 10, juror number 13, 16, 17, and juror number 19. 2 of these jurors were actually impaneled on this particular jury. The other ones, Ms. Villegas had to use 4 of 5 out of her peremptory challenges in order to get these jurors excused because the court did not excuse them for cause. Once the issue of juror bias came up from the defense counsel, the trial court voir dired the jury a total of 3 times to go back over these particular jurors to see if they still had bias. Now the purpose, Your Honor, of having voir dire in the first place is to uncover someone's bias, to see if they're a good fit to be placed on the jury. It's not to change their mind or change their points of view. It's simply to uncover these things, which is what the defense counsel did in this case. So the judge, he attempted to change their mind, so to speak, by voir diring them 3 times. He then went as far as reviewing and reading to them a premature jury instruction on law enforcement officers and how their credibility should not be deemed any more important than that of a lay witness. I know that your jury instruction is not used anymore, and the court did point out when he was reading that instruction that the reason why the courts of appeals have said, no, we're not going to read this jury instruction any longer is because why put more emphasis on one particular witness and not on some other witnesses.
Counsel, after that instruction was read, did the trial attorneys, were they given further opportunity for follow-up questions, or was that just the end?
It appeared from the transcript that that was just the end, and so that's why the peremptory challenges were used. And you know, when the defense exhausts its peremptory challenges before the full jury is seated, the erroneous denial of a challenge for cause may be prejudicial. That's under State versus Cornwell, that's cited in my brief. State versus Eaton goes on to say that the error is prejudicial if the accused eliminates the challenged jurors with a peremptory challenge and exhausts their peremptory challenges before that jury is seated. And then furthermore, Ms. Villegas argues that pursuant to RC 231343, a prospective juror who has been challenged for cause should be excused, quote, if the court has any doubt as to the jurors being entirely unbiased. here, the fact that the court voir dire these jurors a total of 3 times on the subject and then read this premature jury instruction to them to try to get their mind to change or try to get them to say something differently, that speaks volumes about what the court's doubts were, that the court had doubts, and in fact that he feared that these jurors were biased. And instead of removing those jurors for cause, he allowed 2 of them to remain, well, let me back up. 4 of them were used as peremptory challenges, 2 of them were used as peremptory challenges for the state, and then 2 of the, I believe 2 of them remained on the jury. So Ms. Villegas argues that that the fact that these jurors were left on and were not removed for cause allowed or prevented her from having a fair trial. The 8 prospective jurors declared that they would give more credibility to the testimony of a police officer. This shows a lack of fairness on the jurors' part, as well as an impaired view of their performance as jurors. On Wainwright versus Witt, which is also cited in my brief, it is excluded, or jurors should be excluded for cause when their views prevent or substantially impair the performance of their duties. The fact that they said what they had said on various occasions and is listed throughout the brief, we would argue that that is in fact the truth. Just so that I can emphasize the 2 jurors that did remain on the panel, juror number 9 stated that they would give more credibility to police testimony. Juror number 19, who was also impaneled on the jury that convicted Ms. Villegas, said that they would consider police testimony higher than that of other witnesses.
Counsel, do I understand correctly that when all was said and done, there was 1 peremptory challenge left for the defense?
No, there were all 5 peremptory challenges were used.
Okay, thank you.
Yes. It's just one of them was used for a different person for a different reason.
Okay.
Did juror number 9 and 19 indicate to the court that they could follow the instruction that he gave?
Juror
Keep
number...
an open mind, or...
Yes, so juror number 9, once the court read the law enforcement jury instruction, he simply stated, I have an open mind. He didn't go back and change his position saying that he gives a lot of credibility to police testimony or that he has the utmost respect for them and take their testimony pretty seriously. All he just said simply was, I have an open mind, and therefore the court did not remove him for cause. He didn't expound on that, and so the fact that he says he has an open mind doesn't negate the fact what his core beliefs were that he had originally had stated. And as far as juror number 19 goes, juror number 19 stated that she was impaneled and rendered the verdict, stated that, juror number 19 never changed her position, that she would consider police testimony higher than non-police testimony. So that's
I think Judge Callahan asked this, but after they made those statements, I can keep an open mind. Could the court give defense counsel an opportunity to follow up on those answers?
Your Honors, again, it appears as though it just ended, and that the jury was impaneled.
Thought I might be asking the same question, but I want to make sure.
Yes. So another argument we made, Your Honors, was that the text messages were, and I don't know if I don't believe I've said this, but if I could be allowed 2 minutes for it.
Yeah, you have just 6.5 minutes right now, so I'll let you know when you're down to.
Thank you. The text message, we would argue, were biased. So here in this case, Your Honor, this was a case between a girlfriend and boyfriend, where the girlfriend, Miss Villegas, has been convicted of killing her boyfriend, Mr. Capers. There have been several text messages that were introduced into evidence. One argument we make is that under Evidence Rule 803-6, it's a business record and should not come in. The difference between a complete business record here and this particular record is that the law enforcement officer got on his computer and extracted the information from his computer off of the phones rather than getting the actual records from the cell phone companies. So we would argue that they lack trustworthiness, as well as this 803(6) business records exception. But more importantly, what we would argue, Your Honors, is that these text messages were under Evidence Rule 403A, that they were highly prejudicial and that they should not have come in. And if I could, Your Honors, these messages were very rude, they were very crass, and I have to tell you what some of these messages said, because we believe that this is one of the things that led to Miss Villegas' conviction. May God have mercy on your soul because you're fucked. Whatever, bitch, I know what I'm talking about. It's cool. I hope your drinking rendezvous was worth it. You have left me here all day. I haven't had a fucking thing all goddamn day. On top of everything, my baby is having a bad day. She needed you and you abandoned her. Fuck you, bitch. You're a fucking dead whore. And so these are just a very, very small sampling of thousands of text messages that the court allowed in and for the jury to see. These text messages spanned a time of approximately 3 months prior to this shooting. And so if you look at this language, our argument is that it certainly is prejudicial to Ms. Villegas. And in fact, in the transcript on page 361, lines 1 through 8, the trial court admitted that the messages were prejudicial to Ms. Villegas. But then they justified it by saying, well, they're also prejudiced to Mr. Capers because it indicates his involvement in illegal trade. The reason why he said it was prejudicial against Ms. Villegas was because of their language, the rudeness, the vulgarity of these messages. So
More so than the threats?
well, I'm sorry.
More so than the threats?
Yes, he didn't say anything about the threats at that point. And so, I mean, especially when you have thousands of them, so here, I have them. You come back and get them. That way you can visit, okay, I'm sorry, that's, fucking whore, my phone is about to die, bitch. When the fuck are you going to be here, skunk? I mean, there might have been 2 or 3 messages that said, you're gonna die. A lot of them are the fact that they, or both of them really, just had a very, very poor way of communicating with each other. And I think that these text messages indicate, if you were to, I think the court reasoned that if they can look at it as a whole, maybe they'd see that it's not so prejudicial against Ms. Villegas. We would argue that it is.
Pose this question to
Sure.
you. Your client originally, the first count, if I'm right, was murder under A1, purposeful murder.
Right.
She was acquitted of that, but found guilty of a lesser included reckless homicide.
Yes.
Arguably, weren't those text messages helpful to her?
Well, so the other argument is the judge, this is the other thing, the judge did not make his ruling until after voir dire. So he instructed counsel not to mention anything about the messages in voir dire, which, if you talk to a lot of practitioners, they would argue that voir dire sets up the majority of their case, and so they weren't even allowed to argue anything about the text messages, so the decision wasn't made until afterwards. And the decision was made based on what the defense counsel, what their potential defense was, not that in fact they were going to assert this defense, because it hadn't been stated for sure at that point, and defense counsel put that on the record, that it hadn't been stated for sure.
You're into your rebuttal time.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court, Lindsay Paprocki on behalf of the appellate state of Ohio. At the outset, with respect to her assertion that the trial court erred when it failed to excuse biased jurors for a cause after they had pledged to give more credibility to police officer testimony, this court's standard of review is important. because the determination of juror bias necessarily involves an assessment of credibility, a court of appeals must give deference to the trial judge who sees and hears the challenged jurors. Therefore, the standard of review on appeal is an abuse of discretion. Here, during voir dire, Villegas' counsel questioned the prospective jurors as to whether they believed a police officer's testimony should carry more weight than any other witness. The state acknowledges that several potential jurors responded that they may tend to give more weight to the testimony of a police officer. As a result, Villegas moved to challenge for cause 10 prospective jurors because her counsel argued that they all indicated that they would give more credibility to the testimony of law enforcement officers. The state submits, however, that although those prospective jurors initially made statements during voir dire about granting greater weight to law enforcement testimony, which may have cast some doubt on their impartiality, their qualifications to serve as fair and impartial jurors was sufficiently rehabilitated by the trial court's further examination into their views on the credibility of law enforcement testimony. As indicated by Villegas' counsel, the trial court then individually questioned each of the prospective jurors as to their perceptions on the credibility of police officer testimony. He then based on the responses, the trial judge then gave a general instruction on credibility to the prospective jurors and indicated that they were to give law enforcement testimony no more credibility than to any other witness. The trial judge then questioned each prospective juror again, specifically asking them if they were to receive a jury instruction on credibility, how that would affect their ability to consider a law enforcement officer's testimony. All but 2 prospective jurors, number 5 and number 15, who had previously expressed a potential bias, has expressed a commitment that they would have an open mind, have no problem, and that they could follow a jury instruction, if given, to hold law enforcement testimony in the same regard as any other witness.
Did 5 end up on the jury?
No, he did not. He was removed for cause.
That was a cause.
And 15 was also removed for cause. Therefore, those potential jurors who could not be rehabilitated were in fact removed for cause by the trial court. So we would argue that the trial court properly exercised its power in granting the motion for cause there, and that any prejudice that resulted on the ruling for cause was not prejudicial because Villegas failed to remove the contested jurors with a peremptory challenge. Next.
Now, I thought Attorney Wilms indicated juror 19 initially expressed that she would give police officers' testimony more credibility and never changed from that position after being instructed. And remained on the jury panel.
In my notes, I have that all but 2 prospective jurors, number 5 and number 15, had previously expressed a potential bias. So I would have to clarify that in the briefs.
All right, I'll check the record.
Okay, thank you. So as initially noted, Villegas initially challenged 10 jurors for cause, and after the trial court removed jurors 5 and 15 for cause, Villegas maintained a continuing objection for cause on 5 prospective jurors. That was 1, 10, 8, 9. 1, 2, 8, 9, and 10, I'm sorry. Villegas ultimately used all 5 peremptory strikes and removed jurors 1, 2, 8, 10, and 13. So the state would submit that although Villegas challenged prospective juror 9 for cause, she did not utilize one of her peremptory strikes to remove that juror, but instead used a peremptory strike to remove prospective juror 13. Villegas now claims that prospective jurors 9 and 19, who were impaneled on the jury, were biased and should have been removed for cause. and asserts that the trial court abused its discretion when it impaneled jurors 9 and 19, even though she could have used a peremptory strike to challenge jurors 9 and 19 and didn't even challenge juror 19 for cause. The Ohio Supreme Court, however, has said that failure to eliminate a contested veneerment with a peremptory challenge would render any error in overruling a challenge for cause as non-prejudicial and thus not reversible. As in regard to the text messages, Villegas' next two assignments claim that they were improperly admitted, and there were a number of text messages sent and received from the cell phones that belonged to Villegas and the victim Lamar Capers. Villegas has conceded that this court should proceed under a plain error review on these assignments of error, and her first claim is that the exhibits were not properly authenticated as a business record. The state would submit that the business records hearsay exception in Evidence Rule 8036 and its authentication requirements did not apply in this case because the testimony of the detective clearly demonstrated that the extraction reports containing the text messages were not a business record. Detective Sumter, who was the lead detective in this case, was specifically trained in cell phone extraction and testified that he extracted the data from the cell phones using a computer specifically designed to read cell phones. After extracting the data from the cell phones, he completed a number of extraction reports from the cell phones that contained the text messages sent and received from the phones and the corresponding dates, details, and content of those text messages. Cases from appellate courts, including the 2nd District, specifically State v. Norris, have held that the business records hearsay exception in 8036 and its authentication requirements do not apply where text messages were not subpoenaed from the cell phone company itself, but rather were extracted from the phone during a detective's criminal investigation. And also, it's important to note in this case that Villegas took the stand, and therefore she herself authenticated the text messages by identifying her personal knowledge of the content and identifying herself as the sender of those text messages. In her last assignment of error, Villegas contends that even if the text messages were properly admitted otherwise, that they should be excluded because of unfair prejudice over probative value.
If you were to believe the text messages and all the threats that were in there, then wouldn't she have been convicted of murder instead of reckless homicide? I mean, if they were threats to kill him, but the jury apparently didn't believe that that was her intent, or they would have selected a different consequence.
I'm sorry, can you repeat that?
I guess I'm wondering, where's the prejudice of the bias in the text message, the bias and the text messages when she wasn't convicted of murder? I mean, there was no specific intent to murder this guy. She even said, it was an accident, I didn't mean to kill him, it was an accident.
Right.
And then, ostensibly, you could think that the jury believed her.
And therefore, we would argue that there was no unfair prejudice to the admission of the text messages.
Or bias, because they
Right.
ended up believing her.
Right. So that would be the argument that there's admission of evidence by the prosecution is necessarily prejudicial to some extent, but it's not always unfair. And the requirement under 403 is that the evidence be unfairly prejudicial. And here, we say that the evidence of the text messages was relevant to the way that Villegas and the victim, Lamar Capers, consistently communicated with one another leading up to and at the time of the shooting. And the judge, in his ruling on the motion in limine, indicated that the text messages were relevant to exactly that point, the mindset of Ms. Villegas, because he anticipated that there was going to be a inclusion of a lesser included defense or a lesser included offense, a request for that. So we would just argue that the text messages were relevant and that they were not unfairly prejudicial. And based on that, we would ask that the conviction to be affirmed. Thank you.
You have just over a minute. Sorry.
Thank you, Your Honors. Your Honors, let's not forget that Ms. Villegas was convicted of murder, count 2, and that's what she was sentenced on. The court admitted the messages were prejudicial to Ms. Villegas in the transcript on page 361, lines 1 through 8, because of their language. The jury was prejudiced. She was convicted of murder in this case. She was prejudiced because of the language. She was prejudiced because these messages stemmed back for 3 months. She was prejudiced because the last message that had any communication was 3 days prior to this incident. So whether you believe that, whether the jurors believe that she was, that it was an accident or not, she was convicted of reckless homicide as well as murder.
Counsel, just, maybe I misunderstood because that happens a lot, but I thought at one point that it was actually defense counsel who said, and I understand, okay, if you're going to put these in, put them all in so we have the context.
Well, exactly.
And did that all include the 3-month period then?
That is correct, Your Honors. And so the defense counsel did object to those messages, but since the judge said, well, I'm going to let hers in, well, if you're going to let them in, then you need to let all of them in. It's as if she was boxed into a corner and had to say, well, look, if this is going to be your decision, then let all of them in, not just the ones from her. And in addition, we would argue that any renewal of any sort of objection from the defense counsel would be plain error if in regards to her not continuing to object that the text messages be put on the record or put into evidence.
You must be reading my notes.
Oh.
This was a motion in limine, correct?
Yes.
Was there another objection, and I don't even care what the grounds were, actually during the trial?
Yes, Your Honors, but it was limited.
Okay, that's fine, but there was an objection.
There was, but it could have occurred more often perhaps. But so again, as far as the juror bias, keep in mind that jurors number 9 and 19 were impaneled. Your Honors, we would ask this court to reverse and remand. Thank you so much.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and on the Supreme Court.
Thank you.
Thank you.